Hello, everybody. I know how much you all have missed Ava, and I'm so sorry that it was 3 days away without Ava. I was sick. I'm still sick. It's a bad bug. Yeah. So I'm working through it, and I needed to be on tonight. I may have to go off camera every once in a while, but I missed you guys. I missed all of you, and I'm getting swatted in the face. In the face. Hey, Bandit. Would you mind not falling off the desk, please? You cute little thing. Hello, Fozzie in Texas, my sweet love. Hello, Mortimer Duke. You sweet man. Let's light this candle. Yay. Hello, Catherine Gaston, sweetie. Oh, bless you. Cutest little kitten sneeze ever. Hello, Nana Laura. I missed you so much. Hello, Linda Applegate. Hello, K-John Boom. Yeah, they ordered it a couple days ago. It's just now being delivered. Hello, Spider-Man honey. Oh, I've been trying. My mom had, I don't even remember. It was a long time ago. She had mentioned something about bay leaves, and that if you boiled bay leaves on the stove, and just let them like simmer, she said bay leaves kills viruses in the air. Now, whether or not that's true, I have no idea. But what I do know is I spent 2.5 days in absolute heck. And then today I put a pot of water on the stove with a whole bunch of bay leaves, because I had bought them in bulk a while ago. Bought 3 big bags of them. And yeah, I started feeling better today. So I'm sure part of it is stress. And part of it is that I have a really weak immune system. And, you know, part of it's just cruds going around. Put that all together. She nearly did. She nearly did. Oh, yeah. I'm still not well. I'm still not well at all. But I have to be here. I have to. This is my sanctuary. This is my sanity. It's also my job. You know? So yeah, I had to come back. And I'm gonna try to, not miss any more. But that's all gonna be dependent on lots of factors. I almost threw a blanket and pillow in the tub last night. That's how bad I was. It was awful. It was so bad. Hello, C-Rex, my love. Hey, you are bossy. I will pet you when I pet you. It's more tummy related, more than anything. Tummy related. which is why I think that you will not call the shots on what I do with my hand. You will stop that, Miss Sassy Pants. I will give you your treats when it's time. And I will pet you when I want to. I mean, I always want to. But, I lost my train of thought. No, it was mostly tummy related, which is why I think stress had a lot to do with it. You know, dealing with the house issues and my brothers with the house issues. It's not pretty. Bay, sage, and rosemary all help. Cool. Yeah, my mom didn't practice it. She said it, you know, she just didn't do it. But then when I had my own house, this house, I got sick one time and I did it. I put bay leaves on the stove in a big pot and boiled them for, you know, when the bay leaves would all sink to the bottom, I would just add fresh ones to the top and I would just keep topping it off with water all day long. And I love the earthy smell that it gives the home. And it moisturizes the air, which I needed to do anyways. We were getting shocked. Every time I would go to touch one of the animals or a light socket or anything, zap, big blue, you know, zap. And, excuse me. And, so yeah, I needed the moisture in the air. And so it's killing two birds with one stone and hopefully a lot of viruses along with it, if that's true. Oh, I have a ginseng tea. And I know honey is really good if you get local honey. It's really good for allergies, especially. Honey has all kinds of healing properties to it. Hey, Tiana Miller, honey. Speaking of honey, you're just too sweet. Oh, I know I'm not required to, but this is required for my mental health. You guys make me happy. Take you guys out of my life and I'm no longer happy. Hello, Loud Elvis. Welcome, sweetie. Hello, CE. Hello, Sir Philip. Good to see you, honey. I hope you and Robert and Russell are all doing grand. Read about phytosides, phytonsides, phytonsides, phytocities. I don't know. Things beneficial that come from plants via smell. I bet there's a lot that fall into that category, like eucalyptus and lavender and lots of those types. Mints. A lot of the mint family. They've got a lot of good stuff. It was 114.8 Fahrenheit in the shade outside today. In the shade. No, thank you. Ooh. I don't like it too cold. Like we've been having like negative 12s and the real feel after wind chill was like negative 24. It was decent-ish today, but I would take that over this any day. Because I can put more clothes on, but there's only so many clothes I can take off and still be unarrested. Cedar, pine, garlic. I love garlic. Oh, I love garlic so much. Too much, actually. There is a thing as too much garlic. You can get very, very sick from too much garlic. I have done it. Hello, Allison, sweetie. I love you. Oh. Nope. That's why I will never live in Australia. Come at me, bro. It's about time. I knew you didn't see your greeting. Hello, Mortimer Duke. Oh, see, now there's incentive to move to Spain. I can't speak much of the language, and what I can speak is incorrect because I know Mexican Spanish, and Mexican Spanish is not Spain Spanish. And in fact, there are some words that mean almost the exact opposite of each other, even though they're said the same. And you can get yourself in some big trouble accidentally saying something in Mexican that's actually when you're in Spain. Yeah. Oh. Is it treat time? And I know this because my neighbor, he's from Mexico, and his girlfriend was from, where was she from? I want to say it was Colombia, but I might be wrong. My aunt's from Colombia, so I might be getting her mixed up. But yeah, I can't tell you how many times they got in fights, like actual like fights about he would say something in Spanish, but she took it wrong because in her Spanish, it was different. And then he'd have to come over here and talk to me in English and have me then use my translator app to calm her down. My gosh. It was dangerous. It's not as dangerous as Argentine Spanish. Well, I don't know. You never met these two. Oh, no. I bet so. Excuse me. Oh. She is very demanding. I blame all of you. That is perfect. That is the slogan for Australia. Oh my gosh. Oh, whoops. Oh, so you you don't want to go out and catch cats? Yeah, it's all your guys' fault. Yes, especially you. Oh. Okay. I'm gonna put the cases on. We got a good lineup tonight. But I'm gonna put them on and I'm gonna turn that heater down because I can't regulate my temperature for nothing. And at the moment, I am very uncomfortable. Oh, I can see how that would be problematic. Yes, absolutely problematic. But, you know, if they're looking for a how-to manual, oh no. This is why I just stick to mine. Oh, root in Australia, to root is to do the naughty bum. I know that one. Oh, that's where we're at. That's where we're going with this. Yeah. The streets will be lined soon enough. There are lots of those that are close but mean vulgar things. Yeah. Oh yeah. Catherine Gaston, isn't this where we always end up? Doesn't matter where we start. This is where we end up. The most ambiguous phrase of the evening. It would come from none other than Pop Heels. Well, hello, Bandit. Hello, my beautiful baby girl. Oh, you guys, see, this is why I need you. This right here, this is exactly why I need you. Don't you dare. Hello, hubby. Hey, tonight's cases, we're starting with judge jokes. That's what I'm gonna call him from now on. He doesn't quite fit Judge Dad. He's not quite Judge Dad, like Reno Judge Dad. This guy, he's Judge Jokes. That's what he is, because he's always got those little quips that he just, hits the defendants with. Hello, Robert from Cologne in Germany. How you doing, sweet love? So I've heard. Okay, guys. Oh, now my tummy hurts from a whole new reason. Thanks a bunch. No, seriously, thank you. Well, that's your fault, Catherine. You're the one supposed to hand out the depends on these streams. Oh, you guys, I love you all so much. Thank you so much for being a part of my life. What a boring life it was. I didn't know it, but it was, because this is so much better. Oh. Oh, now I just gotta figure out where I put these cases tonight. yeah. This is where. I really got to do better at naming them, though. One named Good Stuff. One named Crane Tonight. Yurta. YouTube. They make sense once I remember what's actually on them. But, and if I can't remember what I put on them, then it's just, yeah, I got to do better for myself.
In the matter of People versus Haskins, 25438.
Good morning again, Your Honor. Aaron Coltrane on behalf of Mr. Jordan Haskins. He's the defendant in this matter. Your Honor, we are here on an arraignment for motor vehicle unlawful use. I have gone over the complaint with Mr. Haskins. We would waive the formal reading. Mr. Haskins would stand mute in this matter. We would respectfully request a referral to the Office of Assigned Counsel. And we would ask that you just set a reasonable bond, Judge. I do believe he was on parole at the time, so his bond is revoked. But there is a case that he has a revoked bond in.
Ms. Tracy, are you here on Mr. Haskins' case?
He is currently with PTI, so he is in CMH's.
Yeah, I think Judge Fickner has him seeing somebody soon as well, if I'm not mistaken. Well, let's do this. Pre-exam conference is February 5 at 11 a.m. Preliminary exam is February 12 at 9:45. Sounds like every court now has had Mr. Haskins before them, including this court now. Was hoping to avoid Mr. Haskins, but I guess I can't. All right. Since there's a hold, the people have done a bond recommendation with the 75,000, no 10% bond. Mr. Haskins kind of a concern to society with anyone that has diesel engines. So I think I'm just going to set bond at 7,500 cash surety, no trucks, no tractors, no car dealerships. No police cars, no mosquito trucks, nothing. No, only bikes, bicycles. That's all you get. All right. All right, good luck, Mr. Haskins. We'll see you on the 5th, I believe. And People versus 45306. Aaron's just for the record.
Good morning again, Your Honor. Aaron Coltrane on behalf of Mr. Malcolm Banks. He's the defendant in this matter. He's joining us from the Saginaw County Jail. Your Honor, this is an arraignment for an incident that occurred last year in September. I did go through the complaint with Mr. Banks. He does understand the substance. We would waive the formal reading. Mr. Banks would stay mute. We would ask for a referral to the Office of Assigned Counsel. And we would also be asking for a PR bond in this case, Judge.
Well, if I look, is Mr. Banks on probation or parole?
No.
He is not, Your Honor.
He was discharged in early, just a few years ago, in the last couple of years.
Your Honor, just for the record, and I will send you this address too. He does have an updated address that is not with the alleged victim in this matter, so there's no issue with violation of the no contact order.
Is he living in Saginaw or is he living in Flint?
He is actually just moved down to the Burton area.
All right.
He's going to be far away, but he's still going to come to court, of course.
Far away. Citizen of the Year award, he does not get. Frequent flyer points through the criminal justice system, he does. Where did they pick Mr. Banks up at?
Where were you picked up, Mr. Banks?
I was picked up. I didn't know about the warrant, so I was at my baby mother's house. I didn't know anything about a warrant. I was at my baby mother's house and the police came and they said I had a warrant.
Funny how that thing happens, doesn't it? What's the last name of, child's mother?
Stewart. Like, I didn't put my hands on her or anything. We just argued. That's what we do.
Hey, Mr. Banks, I'm gonna just stop you right there.
That's odd, because shares the same last name of the victim. All right. Well, I'm gonna do this. I'm gonna do a PR bond, but it's gonna be with no contact with Miss Stewart. And you have to attend CST counseling pretrial programming within 5 days of release, so you should do it this week. I will check with Miss Joseph at CST if you have contacted her with regard to pre-programming. Since you're down in Burton, although there's no Saginaw went down to Burton. Since you're down in Burton now, Miss Joseph will accommodate through Zoom or in person, since you might be up here. Are you working at all?
Go ahead, answer now, you're off mute.
Yes, sir.
Where are you working at?
I work at Beam Staffing.
Okay. Just get all of Miss Joseph so you can address, so we don't have to have you come through and maybe you get some tools necessary to interact with women. All right, good luck with everything. Take care, be well, be safe. Thank you.
Thank you very much, sir.
Thank you, Jay.
Thank you, Your Honor.
Have a great day, guys.
I just love that judge, and I love his 1-2 punch humor, but it's always like you got to be listening for it. Like just when the guy was saying, "Well, I didn't put my hands on her or nothing," and the judge, he's looking at the paperwork and he goes, "Well, that's odd because that's the same last name of the victim." You know. It's like, yep. The judge is always cracking those. He's got those quick-witted little quips, but you got to be listening for them.
State of North Dakota versus Amber Dawn McIntyre, file 47-2025 CR9. Mr. Gonzalez appears on behalf of the state. Ms. McIntyre appears personally without counsel. Sir, were you present in court when your rights were read to you earlier?
Yes, sir.
I apologize, ma'am.
Yes, sir.
All right. One of the important rights you have is the right to be represented by counsel at every stage of the proceedings. You have the right to hire a lawyer or apply for a public defender or represent yourself. It looks like you already applied for a public defender, and based on your income, the clerk's office denied your application because you're substantially over the public defense income thresholds. So how would you like to proceed with respect to your right to counsel today?
Represent myself.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, sir.
All right, ma'am. And just so you understand, if your financial circumstances change, or if you are categorically unable to retain a lawyer if you want one, you can always reapply for court-appointed counsel. But typically, if your income is above the financial guidelines, you would need to demonstrate the efforts you made trying to secure counsel by saying, I contacted these 7 lawyers and their retainers are X $1,000, Y $1,000, Z $1,000, and the like, and I just can't do that. Usually it requires you to submit a monthly budget demonstrating your financial need in an affidavit form, and then the court can reconsider and override the guidelines. But that's something that's not done very easily, and you have to provide some documentation before the court would consider that. Understand that, ma'am?
Yes, sir.
Right. Have you received a copy of the charging document in this case?
Yes, sir.
Is your name and date of birth correct on that document?
Yes.
You have the right to have that document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing it?
Yes.
All right. So The state alleges that on or about December 12, 2024 in Stutzman County that you committed a criminal offense of violating a disorderly conduct restraining order by having physical contact with or coming within 50 feet of an individual with the initials CL, and that you knew a disorderly conduct restraining order had been issued on November 6, 2024, and that you were served with a copy of that disorderly conduct restraining order on December 13, 2024. So you were in court when the court issued the disorderly conduct restraining order, and then you were later served on December 13 with a copy of the order protecting CL. Do you understand that?
Yep.
Mr. Gonzalez, I want to make sure I understand. Is this an allegation of a violation of the temporary order or the permanent order?
I believed it was the temporary order initially. I would have to check the records a little bit more, a little deeper, but I do believe that it was just the temporary order at first.
Well, I think that your complaint, you might need to do a bill of particulars or allege specifically, because ordinarily when a temporary order is issued, that remains in effect until the permanent order is served. So just, I want you to be really clear about what order you're alleging has been violated, whether it be the temporary or permanent, on December 12th, because if it's the temporary order and that was not served until December 13, this may not be a violation. If it
Your
was
Honor,
the permanent.
Apologies for interrupting. This is the actual disorderly conduct restraining order, the permanent order. I do have it here in the file itself. It seemed to be, this was the one that was on the 6th of November, 2024. So this was the permanent, not a temporary one.
All right. And so was there a temporary order in place until December 13, 2024? Usually those orders are issued on an ex parte basis until the permanent hearing. And that's why I'm trying to make sure I understand.
I understand, Your Honor. I'm just going through the order in itself. What I have here is that it was heard by the court on the 6th of November of last year. There's findings made on the record. I'm looking at the important notices, and that that the order would remain in full force until June 1st of 2025.
All right, thank you. And so, ma'am, as charged, that is a Class A misdemeanor. It carries with it the maximum possible penalty of 360 days in jail, a fine of up to $3,000 or both. There are no applicable minimum mandatory penalties. However, if you're convicted of that offense, the court is required to impose certain court fees. In your case, those court fees total $360. If your conduct caused any loss or financial harm to another person, the court's required to order restitution, which is a financial award to make that person whole financially. If you're not a United States citizen, this offense can carry with it adverse immigration consequences. There may be other collateral consequences the court has not explained to you. Nevertheless, those are real consequences. Do you understand the nature of the charges and penalties as I've read them?
Yes, sir.
All right. And so in misdemeanor level cases, the court is going to take a plea of either guilty or not guilty today. If you plead not guilty, the court will schedule further proceedings and set your bail. If you plead guilty, there won't be any trial of any kind. You'd be waiving those rights that were read to you earlier, and you likely would be sentenced today. Do you understand what happens if you enter a plea of not guilty or guilty?
Yes, sir.
To this charge, violation of a disorderly conduct restraining order, Class A misdemeanor, how do you plead, guilty or not guilty?
Guilty.
Before you do that, Mr. Gonzalez, what would you recommend to the court if Ms. McIntyre were to plead guilty?
Were she to remain with her guilty plea, I would just be recommending a 360 days. If there was any, have you served any jail sentence at all? No. Then it would just be 360 days suspended for 360 days of unsupervised probation, a distance provision of the 50 feet, the no contact with the individual with the initial CL, and the mandatory court costs and fines. I'm not looking to put the Miss McIntyre into jail, not looking for supervised probation, really here to ensure that the no contact is being met and having a 360-day sentence with the 360 days of unsupervised probation, I believe that meets my qualifications and achieves the goal that I'm trying to reach here today.
All right. And are you offering that as a plea agreement that's binding on the court or as a sentencing recommendation to the court?
I would hope that it would be binding if you're in agreement, ma'am.
That's fine.
All right. So, Mr. Gonzalez, you're presenting that as a Rule 11C1C binding plea agreement?
This is correct, Your Honor.
All right. And ma'am, what that means for you is I have two options. Well, three options really, but in your case, two options. I can either accept the plea agreement as it's been presented and sentence you accordingly, or I can reject the plea agreement and tell you I'm going to sentence you more harshly, or I could sentence you more harshly than what the state is recommending. It could be more favorable to you as well. You won't know that at the time, but you, in a binding plea, if I do something different, if I reject it, you would have the absolute right to withdraw your guilty plea and have a trial if you want. If I accept it, I would be bound to follow the recommendation or the joint plea agreement and include that in the court's judgment. I wouldn't be allowed to deviate from the plea agreement, and if I did, you'd have the absolute right to withdraw your guilty plea. When you listen to that rights video, Judge McCullough explained to you the process that happens when a person offers a sentencing recommendation, which is not binding on the court. In that circumstance, when it's a sentencing recommendation, even if it's a joint sentencing recommendation, the court is free to impose whatever sentence it feels is appropriate. And then you would not have the right to withdraw your guilty plea unless you established that it was a manifest injustice not to do so. Do you understand the difference between a binding and non-binding plea agreement?
Yes, sir.
And are you intending to move forward here on a binding plea agreement?
Yes.
And so you understand that even if I thought it was too harsh, I couldn't change it. I would have to sentence you according to the bargain you struck with the state.
No, I don't want it.
So I just want to make sure I understand. You don't want that binding plea agreement? Or you want to argue for something different? You want me to, what do you want me to do here?
Apologies, Your Honor. I seem to have some kind of situation where somebody in the gallery is speaking to the defendant, offering advice on how to plead and why to plead, and I'm just kind of having a little bit of issue and concern with this. So I'm just wanting to bring it to the court's attention.
Thank you, Mr. Gonzalez. So I want to be really clear. Anyone in the gallery needs to be absolutely silent. They cannot give the defendant advice unless they are an attorney and they are representing the defendant. So if that person speaks again, I did not hear what was said. The microphone did not pick it up, but if Mr. Gonzalez hears someone in the gallery offering the defendant advice, Mr. Gonzalez, let me know, and I will direct the court security officer to escort that person out of the courtroom.
Understood, Your Honor.
All right. So we're going to start this over. Ms. McIntyre, do you
So
understand that
is
you
the
have?
binding one agreeing to what the state's attorney had said then?
So if you offer a binding plea agreement, what you are saying is, Judge, this is the deal. Sentence me according to the deal. If you don't sentence me according to the deal, then you would have the right to withdraw your guilty plea and have a trial. I would be stuck even if I thought the sentence was not what I would ordinarily do if it was just up to me. I'd be stuck. I couldn't go more lenient and I couldn't go more harsh. I would have to impose the sentence that was agreed upon and presented to me as a binding plea agreement. Okay, and so I'm telling you that I can't give you advice on what to do other than say, here's your choices. If it's presented to me as a binding plea agreement, I must follow the agreement or I must reject the agreement. If I reject the agreement, you can still move forward, but then it becomes a non-binding sentencing recommendation. That means the state's attorney gives me a recommendation, and Mr. Gonzalez has done so, and you can argue for whatever you want to argue for, and I would be free to impose whatever sentence I thought was appropriate.
And typically neither party is happy with it because often it's a meet in the middle kind of thing.
That could be more harsh than what Mr. Gonzalez recommended. It could be more lenient than what Mr. Gonzalez recommended. I can't tell you in advance how I would sentence you because I haven't heard what I need to hear in order to make that decision yet. But that's the difference between a binding and a non-binding plea. Do you understand?
Kind of.
Okay. So are you intending on offering a guilty plea pursuant to a binding plea agreement or not?
I want to go with what the state's attorney said. So whatever one that is.
So you're offering that as a binding plea agreement, correct?
Okay. Yeah.
All right. Do you understand, ma'am, that you have the right to plead guilty and you have the right to plead not guilty? And by pleading guilty, you're waiving the right to a trial of any kind to a judge or a jury. In this case, the default number of jurors is 6. You could demand a jury of 12. All of the potential jurors would have to unanimously find you guilty before you could be found guilty. I said potential and I didn't mean potential. All of the trial jurors, whether that is a jury of 6 or a jury of 12, would be required to unanimously find you guilty before you can be found guilty. You're waiving the presumption of innocence. You're waiving the requirement that the state prove you guilty beyond a reasonable doubt. You're waiving the right to confront and cross-examine witnesses against you, the right to remain silent and to testify for yourself. You're waiving the right to present witnesses and evidence on your own behalf. You're waiving the right to require or to use the court's subpoena power to require witnesses to appear. You're waiving all defenses that you perhaps could have had. You're waiving any and all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case. Do you understand all of the rights that you're waiving if you decide to plead guilty?
Yes, sir.
And do you still want to plead guilty?
Yes, sir.
Has anyone made any threats to you, coerced you, or made any promises to you other than what was just disclosed as a binding plea agreement in
No,
order to
sir.
get you to plead guilty?
No, sir.
No one has told you that you have to plead guilty, right?
No, sir.
Is this what you freely, knowingly, and voluntarily want to do?
Yes, sir.
You've been given an adequate opportunity to discuss your rights, any potential defenses, plea or plea agreement, and potential for sentencing with an attorney.
Yes, sir.
And I understand that you aren't represented by an attorney right now. Do you need more time to think about it before you make a decision?
No, sir.
And Mr. Gonzalez has presented a binding plea agreement. Is your plea of guilty the result of that discussion, and you intend on offering that as a binding plea agreement?
Yes, sir.
All right. So we're going to do this again. You're charged with one count of violation of a disorderly conduct restraining order, a Class A misdemeanor to that count. How do you plead, guilty or not guilty?
Guilty.
Mr. Gonzalez, a brief factual basis.
Briefly, Your Honor, as outlined on the declaration of probable cause in the investigation report, the incident date, December 13th of last year, Sheriff's office took a report of a DCRO violation. The complainant was the mother of the protected party. Stated that they were at a school concert and that the defendant was within 50 feet of the protected party at the time.
Pam, is that essentially what happened?
Yes, by mistake.
Tell me what you mean by that.
So I was sitting in the front row at the Christmas concert watching my daughter. And when she was done, I continued sitting in the front row. And I was preoccupied with my husband and I's friend. They have a baby. And I was preoccupied playing with the baby rather than what was pretty much in front of me, which I guess was where the violation came in. When like I said, I didn't realize she was right there. And if I would have realized that, I would have moved, because it's not like I'm gonna purposely go out and cause this kind of more trouble for me.
Mr. Gonzalez, do you still believe a sufficient factual basis exists?
I can continue reading the investigation report if that clears any confusion for the court. So going back to the Christmas concert on December 12th, 2024, the mother had reported that Amber McIntyre, who was the respondent on the order, was within 50 feet of the order, stated that Amber was seated in the front row of the gymnasium and the bleachers were set up within 50 feet where Amber was seated. CL was on the bleachers during the Christmas concert and was described by wearing a jean jacket.
So there would have been no way for her to view her daughter at the Christmas concert from at least the front row without being in violation.
Miss Boom, principal at the Montpelier School, informed me being the officer in question, that Amber McIntyre was seated in the front row and was within the 50 feet of CL. Amber was described to be wearing a gray hooded sweatshirt. The sweatshirt also said McIntyre at the back of it, which can be seen in the video footage. The officer obtained the video footage from the Montpelier School of the incident. Mrs. Boom, the principal, informed the officers that all the grade concert began at 18:30 hours and CL was in the 7th grade portion of the concert and has been on the bleachers between 1750 to 2000 hours. Officers spoke with Amber McIntyre about the incident via phone, which was recorded. She stated she didn't pay attention, that CL was in the concert, was informed that she was well within the 50 feet, continued to say that she did not realize it. She was informed of the document for the incident, informed that she had kids there, and was informed by the staff at the school that she was well within the 50 feet. So that is what I have as the investigation report that was submitted to the affidavit of probable cause. I can go into I believe that there is an even incident number report that does state pretty much the same thing. Roughly that she was within the 50 feet of the restraining order and knew that she had a restraining order out on place of her with the protected party CL.
All right. Here's what I'm going to do. At this point, I'm going to reject the plea agreement and not receive the defendant's guilty plea at this initial appearance. I think there's some concerns and inadequacy concerning the willfulness of violation. The offense is not a strict liability offense. There still must be knowing and voluntary violation or a willful violation of the court's order. I was the judge that imposed the disorderly conduct restraining order I recall on the record having discussions with the defendant and the parties, which is why it contained a 50-foot restriction instead of a 300-foot restriction, which is the default in those types of proceedings. I'm just going to reject everything at this point and enter a not guilty plea on the defendant's behalf. So I set bail and set further proceedings down the road. Mr. Gonzalez, thoughts on bail?
I was just going through the file in itself and looking to see if there was any clarification to the willful portion that the court is highlighting. And given the fact that the only thing I have is the affidavit of probable cause and as well as the investigative report that doesn't really highlight the willful portion other than reiterating that the defendant did not know, I'm just going to move to dismiss this case, Your Honor.
Case dismissed. Mr. Gonzalez, can you prepare just a one-sentence order for the reasons stated on the record? Case is dismissed.
I can do that, Your Honor, yes.
Thank you. So, matter is dismissed, ma'am.
What's that mean?
That means that this is not going to be on your record. It'll show up as a charge, but it'll show up that it's been dismissed. I'm going to sign an order of dismissal. Mr. Gonzalez has moved not to prosecute the case, and I approve that motion, and I'll sign off on the proposed order when he prepares and submits it.
Okay. Well, thank you.
Ms. McIntyre, just so you understand, you need to be aware of those things. I know that both your daughter and the protected person go to the same school. The reason the court set that 50-foot perimeter was to allow you to attend proceedings involving your daughter. But you just need to be more cognizant and aware of where CL is and stay away from her and not have contact. So here, essentially, it appears as though it might be an accidental contact. You just need to be more aware of that in the future because you are restricted in a way that other parents are not. Do you understand?
Yes, sir.
Do you have any other questions?
I do not.
All right. That matter is adjourned. Thank you.
Thank you.
So the plea almost happened and then almost didn't happen and then almost happened and then almost didn't happen. But if the judge was trying to hint to her in the beginning that he would not have sentenced her as harshly, it sure got through in the end with having it get dismissed entirely. It's going to do one of two things. Either she is going to take it as a gift that, you know, she's not having to do a year of probation on top of having the no contact order and everything else and risking go to jail for a year over, you know, another accidental contact like this one. Or, and I hope this isn't the case, it could embolden her if she was trying to, you know, give the nose to the mother of the child victim. If she was trying to, you know, be like, well, haha, I'm sitting in the front row and there's nothing you can do about it, you know, then hopefully that's not the case. And hopefully it doesn't embolden her to do more things like that again. So I really hope this was accidental contact. And that she was just enjoying her daughter's Christmas concert and didn't even think about the other kid being in it. You know, it's hard to say. This one's fun.
Though we are in court. All right, so this is file 240333 SC. It's the Leonards versus Farmers Disposal. We're here for a small claims case. What small claims means is no one here is represented by an attorney. We're trying to get this done without attorneys. You also have, nobody's asking for a jury trial or anything like that. You're asking for this to be resolved right here in front of me. So first things first, if all parties are ready, willing, and able to proceed here in front of me, I'm going to swear you in. Please raise your right hand. You swear or affirm any testimony that you would give here today would be the truth, the whole truth, and nothing but the truth.
I do.
All right. So, Mr. Camps, I do need to find out what it is that you do for farmers that you're able to answer for them.
I'm
Okay.
50% owner.
That certainly works. All right, so I don't get too much information here before we start, but the information I have on this is just from the affidavit and claim, and so it might be faster for me to start with Mr. Camps. Mr. Camps, do you feel like you at the farmer's disposal there's any money here owed to the Leonards, and if so, how much?
I don't think so, not from me. No, I don't think so.
Okay, then I'm going to start with the Leonards. Leonards, so you're talking about your residence, right? And that a truck from Farmer's Disposal, you said, came and did some damage, took out a pole and a power line connected to a barn and did a certain amount of damage. How do you know it was Farmer's Disposal truck?
Well, my mom witnessed it and watched it happen.
Okay.
And
was there any conversation
he called me and told me that he got into the wire.
And who's he? Mr. Kyle. Okay. Did anyone talk? Was there any talk to the driver right then and there when it happened, or you talked to the company after the fact?
He left.
No, Kyle called my husband right after it happened and let him know that it happened.
But he didn't stick around. He
and
left.
he didn't stick around. He left. But at that time, my mother-in-law had called me because of the fact that the line from the house was ripped off their house and was laying on the ground. So there was a live wire from the house all the way to the barn. Yeah, so we had to call the power company, immediately called them, and they were out in 15 minutes.
Let me ask you a couple questions. When you said Mr. Camp said that, oh, we're going to take care of that, what was the form of that conversation? Over the phone, a text, live conversation?
Several, yes. Actually, I spoke to him. He had, the first time I spoke to him, he told me to go through a buddy of his, which owns an electrical company, and give them a call and get things set up. So we called Rob Miller and had him and spoke with him. Rob requested that we send, Rob requested for me that he doesn't get like electrical pole, because they actually had like a telephone pole in the middle of their yard that went from the house, then a line to the pole, which had a mercury light on it, and then went across the driveway to their barn.
And were you guys was there like that Farmer's Disposal was there in the first place? Was that something for you guys? Was that some sort of contractual thing you guys had with them?
Yeah, he does a weekly pickup there.
Weekly pickup. Okay.
Yeah.
And then how did you get to the number 1860?
What's that? I'm sorry.
How did we get to the number 1860?
Okay, so when I spoke with Rob, he said he didn't get telephone poles. So I called Consumers Energy and they found Beist Electric that would give us a pole. And when I spoke with Beist Electric, which was Chad Weber, he told me that they wouldn't do the electrical work because they would going to be working with Rob Miller. And in that aspect, they gave one estimate of the pole amount, which was $650. And then to do the odd to put the pole in the ground was going to be an additional $650. And then Rob Miller had quoted us saying it was between $500 to $700 for him to put in the pole. I spoke with Kyle and he said,
hold on.
Sorry.
To put in the pole or to put in the electric after the pole gets in?
put in the
Yeah,
electric
Rob will
after.
do
That's
the
what you mean.
Yeah.
So
wiring.
what you're saying is it was $650 to get the pole, $600 to install the pole, and then somewhere between $500 and $700 to put the electrical back up to snuff.
Correct, yes.
That's where the number comes from.
Yeah.
All right. So Mr. Camps, why is it that you wouldn't owe the Leonards any money?
I had been there probably 35 times already to empty that dumpster. And the same routine every week. And I never hooked that wire before. Same truck, same everything. And for some reason, I don't know why, the wire was lowered that particular day, and it hooked on my truck, caught on my truck, and I was able to get out from underneath of it.
So you're saying you agree that it was actually your truck that made this happen. You just think there was something wrong. It wasn't your fault.
Right. I'd been there so many times underneath that wire 35 times prior and never had an issue.
I got lucky 35 times, but not lucky on the 36th time is not a good defense. I really don't think that's a good defense, sir.
And for some reason that day, it hooked my truck.
That wouldn't make it not be your fault. Right?
Okay.
If it was lower, then you should have seen that. It would have been markedly different situation. You know how tall your truck is? How tall is it?
It's 13 foot 0 inches.
So if you see something less than 13 foot, you know you got a problem, right?
It wasn't noticeable. I didn't even.
Why would you tell them you were going to cover it?
I didn't. I said I would help cover it up to half.
Okay. I'm going to give you a minute here, Mr. Camp, to make some sort of argument that I'm going to go for, but right now I'm not going for that.
Okay. That's what I said.
This wasn't,
I don't have.
You have a theory of why it may have not been your fault, but that's not really what I have in front of me. What I have in front of me is it was there, then your truck came, somebody watched it happen. You were even saying, oh, okay, don't worry, we'll take care of this. I got a guy. And you just don't like the number?
No, it's not the number so much. Is I don't think I'm responsible for maintaining their electrical system.
Well, you're responsible if you break their electrical system.
No, not the way I see it. I think they got to maintain it.
So I would make a judgment here in the amount of $1,860 as damages. What I also need to explain is that the Leonards paid certain money out of pocket to get us here today. They had to pay a filing fee and they had to pay to have you served. That was $83. They're also able to collect that $83 on top of the damages. So I just wanted you to know where that extra dollar amount comes from. Now, here's the important part, right? So I'm going to generate this order. It's going to get sent out to parties. Two things. One for the Leonards. The court does not do collections. We do expect that the parties would be in contact with each other to satisfy judgment. And I can't imagine that you would want to appeal this judgment, but then this part is for you, Mr. Camps. If you disagree with what has happened here today, you do have a right to appeal my finding to General Civil. General Civil is back in front of the district court judges. To do that, to appeal this decision, you must do two things. One is you must ask for that within 7 days of today's date. Your ability to continue to fight this closes after 7 days. And two, you must come in and do that in writing. You can't just call on the phone and say, I want to appeal. Do you understand your rights on appeal?
Yes, I do.
All right. Then we're all set for what we need to do here in court. This order will get typed up and sent out to parties. I can go ahead and release you 3 minutes after you were supposed to be here because everybody came early, so you guys got to go first. But we're all set. I'm going to go ahead and release parties. Thank you.
Thank you much.
Thank you.
Appreciate it.
Thank you.
And the answer is, well, yes. Yes, Your Honor, I can be that stupid. In fact, I can be a lot dumber than this. No, he usually says that to the officers to start at a place where it makes sense. That's on the traffic dockets. And no, we don't usually get to see him up close. I mean, this is the first time I've actually seen his face. An average. Now that is saying that the judge's IQ is much higher and the couple's IQ is much higher, but that dumpster gentleman's IQ is so low that it brings the average to 73. Hello, Lisette Panette, honey. Big L for the pole, dude. Yeah, I'm pretty sure pole dude has lived a life of L's.
Right, Ryan, I'll send you a button that has you unmute. It's a public intoxication ticket. Prosecutor just notes say you might want to plead not guilty and have a trial. Does that sound right to you?
Yes, sir.
Awesome. Set for trial. We'll be here in person at the court. Do you have any questions before we move you over to get some paperwork signed?
I'm just not understanding how it's getting to the point where I'm gonna have to go to trial for, completely a misunderstanding. Because the last time I talked to you, you said something about a fight was going on, or the police officers got called into a fight. I'm standing there, I'm trying to pay my tab. The bouncer didn't like that. I looked at him while he was saying, everyone get out, and I kind of looked back at the bar to, get my tab paid, and he grabs me by the neck. I go directly outside. I hear, "This is the guy," and I have witnesses. I was with 4 or 5 buddies.
Right.
I hear, "This is the guy," and they literally grab me and put me in a car, and I go to jail. It's a complete misunderstanding. I've already dealt
Yeah.
with enough. I've added physical therapy to my shoulders now due to the corrections officers being very violent with me. Is that procedure? When you arrive to a jail, you get tossed out of the car on the ground on your face and your arms shoved up to your head. Is that procedure? Or
Yeah, so
because
for
I
the
wasn't violent
PI,
at all.
it's going to be up to the prosecutor to prove the offense. If they can't, then you'd be found not guilty. So if they can prove that you were intoxicated in a public place, then you'd be found guilty. If they can't prove that based on testimony or whatever, then you'd be found not guilty.
That sounds very broad. Intoxicated in a public place. I'm at a bar. It's New Year's Eve. Obviously, I've been drinking, but I wasn't. You know, my Uber was there. I'm not. Yelling at
Yeah, if you
anybody.
weren't intoxicated out in public, then you'll be found not guilty. So
And
it's
when
up
you
to
say
them. They've got
public,
to prove that beyond a reasonable doubt.
when you say public, that means outside of the bar.
Yeah, a place to which the public has access. So it was kind of going into legal areas, but typically that means it's not like your living room, your kitchen, your bedroom. A public place is a place to
Yeah.
which the public has access.
Yes, sir. It just really bothers me, that people are out there stumbling, getting into fights, and I'm just paying my tab and I get ripped out of there and directly into cuffs, into a car. No questions asked, no who's this, what did he do, no nothing at all. And then I get beat on when I would go to the jail when I wasn't physical at all. I would never resist. I'm not that type of person. And especially I'm not going to resist when I'm at the jail. I'm not a crazy person. I know if I'm there, suck it up and deal with it. And it was just a terrible experience, and I just can't believe now I'm gonna have to go to miss even more days of work, more money out of my pocket to go here and just prove that this was a misunderstanding. Would there be any disciplinary actions towards the officer or the corrections officers that are causing me, all this inconvenience for absolutely no reason at all?
Oh no, you guys. He's going to give the jail a 1-star review. Oh my gosh. And to be fair, Judge, I mean, looking at all the places that you listed as what qualifies as not being a public place, being your home and your bedroom and I'm pretty sure the public has access to this dude's bedroom. Let's call a spade a spade.
Yeah, so the court's job is to resolve offenses that have been filed with the court. And so we're dealing with a public intoxication ticket. The prosecutor's indicated that she has enough proof to move forward with trial. You've indicated that you disagree and you want to have a trial on that charge. So it's the job of the court then to work to get that resolved by arranging for a trial date where evidence can be presented in a courtroom, and then we can make a decision to get the case resolved. So that's the question before the court. At that trial date is, what should happen with the citation? Can the prosecutor prove the facts beyond a reasonable doubt? If not, then you'd be found not guilty. If they can, then we make decisions after that.
I'm just wondering,
That's the question before the court.
What evidence would they have? Like I personally know
We're not
the
in trial
bartender.
yet, so I don't know. Yeah, I have no idea because we're not in trial today, so I'm not quite sure what they're going to present. But that's what we'll know the day of.
One more thing. What happens if they say, oh, he was fighting and there's no video? Is it just my word against theirs?
You're not charged with fighting. You're charged with public intoxication.
Okay, but when I talked to you the first time when I was in jail, you said the police were called there for a fight. That's what I'm saying. I just don't want to be falsely accused of something crazy. That was out of
No,
that was your
the only
words, but
accusation is public intoxication.
well, and then when I talked to you that day, it was they got called out there for a fight and picked me up. So there was someone fighting there, and
Yeah,
they
normally if
ignored that,
somebody
I guess.
indicates, like in an arraignment, somebody indicates that they have no idea why they're in jail, I'll pull up the report from the officer and kind of read through a little bit of it to give you some sense of what the officers are saying. So that's probably what that was, is I just read you the officer's report about what they were saying they were called out for.
Yeah, and again, that's why I'm just not understanding what the prosecutor would have, because even when you read me, you were like, this is what you were saying when you were getting arrested. It states clearly what is happening. I was just paying my tab. This is just very, very not normal. If I was doing something crazy, I'd own up to it and just get it over with. But
and that's the point of the trial date, is so that we on the record, evidence can be accepted. We can go over what happened and what didn't happen, but can't do that today in a pre-trial hearing. But at the court date, we'll be able to.
And then the other option would be what? It's on my record?
No, I'm sure the prosecutor, she normally offers what's called deferred disposition to take care of these tickets. It's pay the ticket, don't get any new ones for 90 days, and it keeps it off of your record. But we're setting it for trial. We're not going down that other route, is what you're wanting to do, which is perfect.
Because I was assuming I pay it and it's on my record. So if I paid it,
deferred keeps it off your record.
Oh, okay. I don't think she explained me that well. So if I pay,
normally if in that room she says, do you want to take it to trial, or do you want to do something else? Are you admitting to the ticket? And if you say no, I'm not admitting to the ticket, then she won't even discuss deferred disposition with you.
Oh, okay.
Yeah.
Well, so it's either pay money not on my record or go there and it's not on my record.
Yeah, if at trial you're found not guilty, we lost him. Nope, there you are. You're still here. Yeah, if at trial you're found not guilty, it does not go on your record. That's correct. If you're found guilty at trial, more likely than not, it would create a conviction on your criminal record for public intoxication.
Huh. So honestly, then, because I would lose $250 that day anyway, missing work. So I think I would rather just pay it and do the not get in trouble, because I know for sure I'm not going to do this in whatever set amount of time y'all say. I'm not going to get in trouble. So I think I would rather go that route then. Okay,
it's completely up to you. I don't want you to think that your arm was twisted or anything. I'm perfectly fine setting up a trial date for you and getting that scheduled.
I just want to confirm though, it is the deferred thing where if I pay, it's just don't get in trouble and I'm all good. No record. That's it. I'm okay with that. Yeah, I'm okay with that. Because I would lose that amount of money that day anyway, going there to prove it to y'all,
Awesome. $200, no new tickets for 90 days, keeps it off your record. Any questions?
Does that go with
we get you moved over to get some paperwork signed.
Is that speeding tickets too?
I don't have any speeding tickets for you.
No, like you said, no tickets for 90 days. Does that include speeding tickets or something like that?
It does, but we're not going to revoke you for speeding tickets. Normally, you might be called in for a hearing to talk to a judge on Zoom about why'd you get a new one? But I'm not the judge who does those, but the judge who does those is very reasonable about ensuring if it's a PI charge, don't get any new PI tickets.
Yeah, no, I've never got one, and I probably never will again. You know, I
You don't
shouldn't
have
have
any-
got one that time, but
You don't even
know,
have a
stuff happens.
registration or a blinker charge out of our court. So yeah.
Yeah.
Everything else is clear. This will keep it off your record. Any other questions before we get you moved over to get some paperwork signed?
I do want to figure out how to do a formal complaint on those corrections officers that, you know, did that, because that's not okay. You know, I understand, you know, I was mouthy, but I had a right to be mouthy. I'm going to jail for, you know, absolutely, I did nothing wrong. So
Oh, you were mouthy? I wouldn't have known. Here a minute ago, it was that, you know, they just ripped you out of the car and threw you on the ground unprovoked. Now you're mouthy? But you weren't that guy.
Do that sooner rather than later. Videos are kept for a while, but if I were you, I'd try to get that done sooner rather than later. You should be able to Google where to go for the Denton Police Department, or just show up at the front steps of the Denton Police Department, and they'll help you with that.
that would be great. So yeah, I'll probably just go there and just request all that stuff, and that'll be all good.
Yep. All right, hold on the call. We'll
And
get
then,
you moved over to get some paperwork signed.
Okay, and then one more question. I'm sorry.
Of course.
How long do I have to pay that 200? Is it like an immediate?
No, the clerk will let you know the due date. It's typically about 75 days, 2.5 months out.
Perfect. Easy.
Yeah. Awesome. All right.
I appreciate it.
Yeah, no worries. Hold on the call. We'll get you moved over to get some paperwork signed.
Perfect.
Oh, yeah, that guy was something. Do they now? So I gotta move to Denton, is what you're saying. Oh, yeah, I'm pretty sure all of his complaints are gonna get filed directly into the shredder. You know, all of these titles are taken from something that is said in the cases. Like, I don't just make this crap up. Yes. Everybody's favorite time. Let the discussions begin. Well, if there's a limited number, I'll take his. Ooh, pass them on over, baby. Oh.
All right, sir, are you Kevin Spihar?
Yes, sir, I am.
Okay.
I can't see you.
All right, 1 second. All right, I'm not sure why the video isn't working, but if you're unable to hear me at any point, please let me know, okay?
Yes, sir.
All right, looks like we have everybody else connected, so just 1 second here. Okay, we're on the record now in People versus Kevin Spihar, case number 226450. The record should reflect Mr. Spihar's present today by video from Otsego County Jail. If I could have counsel put your appearances on the record.
Good morning, Your Honor. For the record, Michael on behalf of the people.
Larry Brown on behalf of Mr. Spihar.
All right, and the record should reflect we have Mr. Brunical also present on behalf of probation and parole. Mr. Spihar, you're before the court here today for arraignment on two alleged probation violations. Have you been given a copy of or notified of what the alleged violations are?
I heard. Larry Brown.
I'm sorry.
Larry Brown told me the alleged charges.
All right. And Mr. Brunical, is this would this be a first finding of a technical violation?
It is, Your Honor.
Okay. So Mr. Spihar, I'm going to go through with you a few things with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you violated your probation as alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you. Mr. Brown is present today for purposes of arraignment. If you are found guilty of the alleged violations, the maximum penalty you could face, because they are technical violations, would be up to 15 days in jail. Do you understand that?
Yes, sir.
All right, Mr. Brown, it sounds like you did have an opportunity to speak with Mr. Spehar.
Yes, I have, Your Honor. He would qualify for an attorney. However, I believe he is going to proceed today without an attorney, other than me standing in here. But I believe we are going to be taking a plea today. There is one issue that he has. I don't know if Mr. Brunical would delete this from one of the allegations.
Okay, can you make a record of what that is?
It is it is count 1, condition number 3. The very last sentence, he failed to report after release from the hospital on January 3rd. He's claiming that he called on the 4th, which would probably be within 24 hours. If Mr. Brunical would just delete that sentence, I believe we can resolve this today.
All right, Mr. Brunical.
Yes, Your Honor, I can delete that sentence to proceed.
All right, okay, so the court will strike that last sentence from count 1 of the alleged violation. And Mr. Spehar, is that how you wanted to proceed by pleading guilty today?
Final asking is getting treatment and getting help and paying all my dues, like drug treatment and all that stuff, and get a job and stuff. But it takes time. I made mistakes, and I'm sorry.
Okay, does that mean that you want to plead guilty then?
Sure.
Well, yes or no?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Spehar, you understand again that the maximum penalty you could face would be up to 15 days in jail?
Yes. I have a
And
court
with
date
that-
on the 5th too.
What was that?
I have a court date on the 5th in Genesee County too.
Okay. With that maximum penalty in mind, you want to plead guilty to the alleged violations, is that correct?
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody
Just trying to
promised
do
you?
the right thing.
Yeah. Has anybody promised you anything?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you did violate your probation?
No. I turned myself in like I was supposed to jail and all that stuff. So I'm just doing the best thing I can.
Okay. Let's see here. So it alleges at count number 1 that you on or about December 16th of 2024 that you failed to complete residential treatment and you failed to report to your probation officer as you're required to. Is that true?
No. I was in treatment and I saw my probation officer and I went to the hospital because I was on Suboxone. So, and then I went to another treatment center and I couldn't stay on my Suboxone, so I got constipated and all that stuff. So it's been a long road.
All right. Did you complete the residential treatment as you were required to?
I did not. No, I did not, but I want to.
All right. And did you have a change of address or employment status that you failed to notify your probation officer of?
No, I wasn't employed yet, and I didn't have an address. I stayed at the shelters down there, freaking New Path and all that stuff. So they have like 3 shelters. And I talked to my probation officer. She said, "You can stay at the shelters. Just don't go to your brother's house."
All right, the court finds that there's a sufficient factual basis to support a finding that you did violate your probation by failing to complete residential treatment as required. The court finds that your plea is knowing, voluntary, and accurate, so the court will find that you did violate condition 3 as alleged at count 1 of the probation.
But Your Honor, he couldn't stay in treatment and he couldn't stay on his Suboxone because he got constipated. I tell you guys, I can't make this stuff up.
Violation. Mr. Brunical or Mr. Rolla, how did you want to proceed with regard to sentencing?
Judge, we would leave it to Mr. Brunical to proceed on that since he's the probation agent.
Your Honor, given it's his first technical violation and he's looking up to 15 days jail, the probation department would just recommend jail incarceration up to 15 days.
Mr. Brown, anything on behalf of Mr. Spehart?
On Mr. Spehar's behalf, to his credit, he did turn himself in. He was homeless, as he said. He's going through a lot of things. He wants to get into residential treatment and take care of some of the issues that he's dealing with. He does apparently have February 5th hearing down in Genesee County. So I would like him to be able to attend that, deal with the actions in Genesee as well. So I would ask the court, if it is going to impose a jail sentence here, that it impose no more than the time that it takes to get to February 5th so that he can handle his other issues in Genesee.
All right, Mr. Spehart, anything that you wanted to say today?
I'm just, like I said, I'm sorry.
All right, the court finds that based on the alleged violation in this case, that 15 days in jail is an appropriate sentence. So the court will sentence Mr. Spehart to 15 days in the Otsego County Jail. Mr. Spehart, when did you turn yourself in on this?
Turned myself in on Thursday.
Yesterday?
No, I mean, I turned myself Monday.
Okay. Mr. Brunical, do you have information on how long I just need to get a jail credit for Mr.
Yes, Your Honor. I am looking at notes in our system from his probation agent down in Genesee County. It shows that he appeared and was arrested on the 28th. So jail credit beginning on Tuesday, the 28th.
Okay, so 15 days with credit for 4 days served. The court will continue probation. Mr. Brunical, anything further that we need to address today?
No, Your Honor. Thank you.
Mr. Brown?
Nothing further. Thank you, Judge.
All right, thank you. That's all for
My
this
court
hearing
date on
today.
the 5th.
Okay, that's all for this hearing today.
Oh, that was so much fun. You guys are hilarious. Yep, Mr. Spehard. And apparently Poohard too.
Mr. Julian is before you on simple assault and possession of a firearm by a convicted felon. He is currently in a no bond status, Judge, and this is going to be a 90-day case. The state would show that on or about July 24th of 2024, DKPD was dispatched to 6114 Princeton Park Walk in DeKalb County at 12:30 a.m. in reference to a domestic dispute. Upon arrival, officers spoke with the victim, a Miss McCraney, who stated that the defendant, who is her boyfriend, lives at her home and was at the residence and had been drinking all day. The victim had returned home around 11 p.m. on July 23rd, and after a while, the defendant became a belligerent and irate. The defendant then left the home, went to his mother's home, retrieved a shotgun and a pistol. He returned back to the victim's residence and began shooting both firearms in the air while standing in the driveway. The defendant then walked into the garage where the victim was and pointed the firearms at her because he did not like being recorded. The victim immediately called 911 after the defendant pointed the firearms at her. And when law enforcement arrived, he had already left, but there was a shotgun that they found. Judge, I believe Miss McCraney present, if she would like to make a statement?
Yes, ma'am, I'm here.
Okay. Judge, would you like to hear from Miss McCraney now?
Yes, that's fine. Miss McCraney, we're gonna need you on video though.
Okay, one second. I'm trying to figure out how. Okay.
Okay.
Good morning.
Good morning.
And Ms.
All right.
McCraney, if you could raise your right hand.
Mhm.
Do you solemnly swear or affirm that the testimony you're about to present to this court shall be the truth under penalty of perjury?
Yes.
Okay, thank you. What would you like the court to know regarding bond?
Okay. That I do not oppose a bond, and the night me and Mr. Julia had our disagreement, our argument, it was due to both of us drinking. So I stressed the truth. Some he did not point the gun at me.
That's not stretching the truth. That's lying. And that's actually a crime that you could kind of trade places with him for.
He mostly when he got the gun for protection, because he had got to arguing with one of my coworkers. So he felt like
Miss McCraney, before we go
Okay.
into, we're not going to go into the facts of the case, but
Okay.
as to your opinion on bond, what do you have on that?
I do not oppose it. I'm not threatened by him. It was just a disagreement involving alcohol, so I don't oppose the bond at all.
Do you have any safety concerns for yourself?
No, I do not.
Okay.
No, I do not.
Judge, I have no further questions.
All right.
Your Honor, no questions for the defense.
No questions. Okay.
And Judge, the state is going to be requesting a bond in the amount of $50,000. Stay away from the incident location. No contact with the victim. Report to pretrial services. Do not consume any alcohol. Random drug and alcohol screenings, and not to possess any firearms. And the reason that is the state's request, Judge, is he has a significant criminal history that spans back to 1993. He has an obstruction conviction from 1993, a theft by receiving property, carrying concealed weapon conviction from a 1994 case, criminal trespass conviction, a DUI conviction, as well as a giving false name, driving while license suspended, possession of marijuana, less than an ounce conviction, a misdemeanor battery conviction, a hit and run, DUI, driving while license suspended.
Now, don't get me wrong. I mean, he sounds like a fantastic catch.
Giving false information conviction, a conviction for aggravated assault and criminal trespass from 1995, a carrying a pistol without a license conviction from 1996, a sexual battery conviction from 1996, a theft by receiving stolen property felony and violation of the Georgia Controlled Substance Act conviction from 2002, an obstruction, simple battery conviction from 2002, multiple other driving without license convictions, two more, a disorderly battery and cruelty in the first degree conviction from 2008, driving while license suspended and DUI conviction from 2009, giving false name and driving while license suspended conviction, or driving while license suspended conviction from 2012, forgery in the fourth degree conviction, another driving while license suspended conviction from 2014, a possession of a firearm by convicted felon conviction from 2017, battery conviction from 2015, possession of a firearm by convicted felon, given false information and carrying a weapon without a license conviction from 2021, a DUI and driving while license suspended conviction from 2021, another driving while license suspended conviction from 2021, and this case, as well as several probation violations throughout his history. The state does believe that he is a risk to reoffend and a danger to the community and a danger to this victim. Judge, he's been a convicted felon for almost 30 years and was in possession of 2 firearms, alleged to be shooting at this victim. The state does believe that he is a risk to reoffend given these charges, and that is why the state was requesting that bond amount.
All right. Ms. Brown Melcher?
Yes, Your Honor. Mr. Julian has been in Georgia for his entire life. He was born and raised here. He has 6 children, the oldest being 32 years old, the youngest being 17, and then the next youngest being 18. He does provide for those 2 children. The others who are adults don't need providing, but he is active in their lives. He received his GED in 1998. He does have 2 stents in his heart from a heart attack 2 years ago. That's the only health concern that we have with him being in custody. Of course, this is a 90-day bond motion, Your Honor. He was working prior to his arrest at 404 Concrete in Lithonia, Georgia, as an operator for heavy equipment. Prior to that, he worked at Thomas Concrete. He's been at the 404 Concrete for the last 3 years. He does believe he can return to work once he is able to hopefully get a bond and post a bond and get out. At this point in time, Your Honor, he adamantly denies the allegations. We do have an affidavit from Ms. McCraney who stated something similar to the extent of what she testified to the court today, of her being under the influence and stretching the truth, and that he never pointed the firearm at her. At this time, we are asking for a $20,000 bond. He is charged right now with simple assault misdemeanor and possession of firearm by a convicted felon, and any of the conditions the court deems appropriate, Your Honor. And he does have a separate address from the address that's where the incident occurred, where he can reside with his mom that is in the Stone Mountain area.
All right. So the court is aware that this is a 90-day case and the defendant is therefore entitled to a bond. The state is asking for a $50,000 bond with several conditions. Honestly, Ms. Brown Melcher, based on this defendant's extensive criminal history with numerous felony convictions, several of which involved firearms and violence, the court believes that that request is reasonable and the conditions are as well. So the court is going to set a bond in the amount of $50,000 for this defendant. He will be required to stay away from the victim, Ms. McCraney. He is not to have, will stay away from the incident location. He's not to have any contact with Ms. McCraney. He is to subject to random drug screens and report to pretrial services within 48 hours of release. Is the defendant currently employed, Ms. Brown Melcher?
He was, Your Honor, but he's been in custody since October. So for right now, probably lost his job, but I know he plans on trying to go back and get the job, and he believes he should be able to get it back.
Okay. Well, if he is able to regain his job, and the court does hope so, if he provides his work schedule to pretrial, well, he's not on house arrest, but yeah, he'll just need to provide his work schedule to pretrial services.
Yes, Your Honor, I will make sure he understands that.
All right. Ms. Broussard, any other conditions that the state wishes to impose?
No, Judge.
Okay.
And Your Honor, if we can have the pretrial services number on the order as well, just so he knows where to call and report and all that good stuff.
Okay. So yes, Ms. Broussard, please be sure to include the number for pretrial.
Absolutely.
Perfect.
right.
Thank you so much, Your Honor.
Okay, thank you. Was that your only matter, Ms. Brown Melcher?
That's my only matter. May I be excused?
Yes. See you next time.
Thank you. See you next
All
time.
right.
Hello.
Hello, good morning. Ms. Elledge?
Hi.
Hi.
Yeah, Portia Elledge.
Okay, thank you.
How are you today?
I am doing okay. Just give me a moment, please.
All right.
Now calling 23FB1101 and 20W003404. These are the matters of Portia Elledge. Can I get appearances for the record, please?
Assistant Public Defender Sandra White on behalf of Portia Elledge.
Okay, thank you. And ma'am, I believe you did already state your name. Thank you. Okay. So today is the date and time set for an arraignment in the matter ending in 101. And what I am seeing is an alleged violation of probation. I have a note here that you were arrested on a new criminal charge of RNC stolen vehicle on January 28th, and that's in violation of the no new criminal offenses term of your probation.
Wait. What kind of vehicle? Yeah, you know where I'm going.
And that's per WCSD report number 25-6174. Attorney White.
Yes, Your Honor. We would like to point out that these are allegations. Ms. Elledge is stating that she is fighting all these charges, of course. She does have a job. She believes she has a PR bond on those new allegations. She also has a tether. Is that correct, Ms. Elledge? You do have a tether?
I have a tether on. Yep. I have a job. I completed treatment. Yeah. I've been doing everything Washington has asked me to do. I've been doing everything. Yeah. You know.
Okay. So we are.
Did Washington ask you to steal cars?
Yes, as Ms. Elledge has stated, she has a job, and so we are asking for a PR bond in this matter. She does have a tether.
Okay, thank you. Okay, at this time, the court will set a date and time for the violation of probation hearing that will be February 11th, 2025 at 10 in the morning over Zoom in front of Judge Washington. And at this time, per the judge's order, bond is being denied.
Wait. What bond's being denied? I've been doing everything I'm supposed to do. I have PRs for the other cases. I haven't done anything wrong. Please.
Okay. And so, Ms. Elledge, I do hear you. And you do look a lot better than the last time that I saw you. And I'm glad to see that. Okay.
Yeah, I finished treatment and everything. I haven't been doing nothing wrong.
Okay. And I appreciate what you're saying. Per the judge's order, the allegations are serious. Bond is being denied.
But they gave me
Hearing is
PRs for those
concluded.
other allegations, though. They gave me PRs
Attorney White.
themselves.
Ms. Elledge, we will be in to talk to you.
No.
This is the judge's orders. We can't do anything at this time. Hopefully at the next hearing, we can address your bond again.
Thank you. And I believe that concludes this morning's docket.
Yeah, they gave you PR on the charges, but not on the probation violation that you got the charges while you were on probation. So it makes a difference. If you weren't already on probation, I mean, yeah, you'd be walking free. But she's so good at it. Oh, she needs a spreadsheet. Spreadsheets are not allowed on this channel. They're just not. They're not. No, I banned them. Just ask Auntie M. I banned spreadsheets. I think that's accurate. I know. Yeah, me too. That was my favorite part. I mean, she went from just all smiles and innocence to wait, what? you gotta pull the lip out, get maximum distance. Oh, thank you guys. Oh, you guys made me feel better. Laughter makes it better. It also makes my tummy hurt more. But, you know, you take what you get, right? I really appreciate all of you. Yeah, I heard that one a lot. My favorite one that I ever heard was and this was not my parents that said this one. This I can't even remember where I heard it. But it was either quit trying to kill each other or do a better job of it. Oh, by the way, you guys, something really cool happened. My brother had called me and he told me, hey, I have a couple of jewelry boxes and they're all tangled up. You know, one of them's grandma's. So if you'd like them, you can have them, because I definitely don't have any interest in untangling them. Well, when I got the jewelry boxes, I opened it up and I noticed something right away. And it's weird because the first golden microphone was found in a random tote in my mom's bedroom. And in the jewelry box was the same. They're identical. I don't know if this is just the style of the times, or if it's the actual like match, like perfect match, the other golden microphone. It's so weird because it was the plastic tote on my mom's bed was stuff of my mother's, and the other golden microphone was in my dad's mom's jewelry box. So I don't know how that all works out, but I thought that was so cool. No, they're golden microphones. No, they are golden microphones. See? Look. It is a golden microphone. Oh. Oh, you guys are so cute. Cufflinks. But yeah, I just had to share that with you guys. But all right. I'm gonna go now. I love you all. Thank you so much for coming out and spending this time with me and making me laugh. I definitely needed you. Be safe, be well, sleep sweet, and much love.